Welcome to the You Ask Ballotpedia Answers webinar series on judicial deference. Here with us today is Ballotpedia's administrative state team, Christopher Nelson, Caitlin Stiersky, and Jace Lincoln. Welcome.
Thanks, Megan. Hi.
And so how this is going to work is anybody can ask a question, and you should be able to do that by clicking the raise hand button on the bottom of your screen, and then you can type a question and it will be asked to the panelists who will answer them in the order they were received. And we do have our first question. And so someone would like to know, in the face of ambiguities that give rise to deference, how do scholars think that Congress, agencies, and the judiciary should address these statutory ambiguities?
Well, that question gets right to the heart of what we're talking about when we're talking about deference. So the first scholar we talked about was Cynthia Farina, and she wrote in her article for the expedition that Congress, agencies, and the courts should recognize that whenever agencies got the power to make major policy decisions, it fundamentally changed the original constitutional structure. And so following that constitutional shift, Farina wrote that courts have to make sure that whatever decisions they make about who has the authority to interpret ambiguous laws, they have to establish new checks and balances so that no one of the branches has too much power. Farina acknowledged that maintaining a balance of power between the three branches of government would be difficult for the judiciary, but she said courts have to try because every time they decide a deference case, they affect that balance of power. She said the courts and Congress both altered the original constitutional balance of power, and so they should share responsibility for creating a new balance whenever those statutory ambiguities arise. Kemp Barnett is another scholar we interviewed as part of this expedition, and he said that it matters whether the agency uses its expertise when it's interpreting the ambiguity. So if there's a question that an agency answers that didn't involve that agency's specific technical expertise, there's less reason for a court to defer to whatever the agency said. And then finally, Adam White is another scholar we covered in the course, and he said deference is usually based on congressional intent. So whenever there's an ambiguity, the court would look for what they think Congress meant to say with that provision in the statute. But that specific intent is hard to know sometimes.
Oh, I was just going to add Philip Hamburger's kind of comments on this issue. He proposes that judges can address statutory ambiguities by interpreting laws on a de novo basis. So under that standard of review, the judges would apply their own interpretations of ambiguous laws instead of deferring to those made by agency officials. The judges can then discern the meaning of the ambiguous statutes through context or through judicial canons of interpretation. And then when no meaning can be derived, Hamburger argues that judges should not attempt to attribute a meaning. Instead, in those cases, the law has nothing more to say. And so some scholars in those situations argue that Congress actually should pass new legislation to resolve those ambiguities.
Yeah, just building off those very practical sort of responses, which, by the way, you can find in as many as we were able to curate in the main line of arguments around ad law at bp.org. You can just Google Administrative State Index to find the list of various reforms that people have offered scholars and practitioners in this field. On the executive side, with agencies themselves, one argument that scholars have proposed is that executives can effectively today order agencies to stop implementing ambiguous statutes, right? Putting sort of the impetus back on Congress or the legislative branch to actually write clear statutes.
One scholar that we read in the expedition, Jonathan Siegel seemed to argue that judges do not relinquish their Article 3 duty to interpret the law by deferring to administrative agency interpretations. What do other scholars think about his argument?
So Kemp Barnett argued that Article 3 does not prevent deference. He said Chevron is part of a larger set of questions about the judicial power in general, and it depends on whether courts are deciding a case that involves public rights or private rights. So whether the case is between the government and a private party or between two private parties. He mentioned that there are areas like Habeus Corpus challenges and cases involving awards that come out of arbitration that legitimately limit the court's review powers. But Barnett says that Siegel is right. And he points to experience in other countries like Ukraine that seem to show that de novo review, so courts deciding questions without deference, can stifle the use of agency expertise. But he says the debate over Chevron is really a debate about the people's confidence in the federal bureaucracy. Cynthia Farina looks at the consequences of deference, and she argues that Chevron means that agency interpretations of ambiguous statutes will almost always win, and that since they'll always win, agencies might use court cases about deference to expand their own powers in some cases. Adam White said he was not convinced by the Article 3 critique of judicial deference. He said there's always been space for deference as far as how administrative agencies operate, but having to defend deference in light of Article 3, he said, makes people have to develop their arguments more. And he said that's good just to understand better how the law works. He said deference at its worst comes close to constitutional abdication, but it's not necessarily giving up the court's responsibility to interpret the law. He points out that Chevron step 1 is required before deference is legitimate at all. And step 1 asks whether Congress spoke to the issue at hand and then whether the provision at issue in a case is ambiguous. Adam White argued that Chevron seemed more deferential than the deference precedents that came before it and seemed scarier than those such as Skidmore and Seminole Rock. White went on to say that deference can be constitutional if there are limits on it. He thinks former Justice Antonin Scalia was right about the need for courts to enforce a rigorous Chevron step 1. That way the courts aren't making many policy decisions. They're only deciding these deference cases in cases where there are truly ambiguous statutes at issue. And Adam White also said that adding step 0 to the Chevron process is a good corrective for some of the abuses that different people have pointed out in the judicial deference space. And step 0 refers to things like not even applying Chevron deference to major policy questions. So even before you start looking at an issue, if it's a major question, then that doctrine tells courts not even to apply traditional deference approaches. Finally, White said that Congress should specify what kinds of deference courts should give to agency decisions based on the procedures that agencies used when they were making those decisions.
So those are fairly nuanced approaches. Hamburger, I'll just kind of reiterate his point here. He does claim that deference unconstitutionally prevents judges from fulfilling their duty to exercise their independent judgment when they're interpreting statutes. And specifically with regard to Chevron deference, Hamburger claims that it violates the due process clause of the Constitution by requiring judges to exercise systematically biased judgment, which actually favors the government.
Yeah, it's important to mention that very notable sort of school of thought, administrative law, because obviously if there is a perceived duty to interpret the law, then by definition, deference that's too broad, right, obviously is relinquishing in some sense that authority. And so it is important to recognize that, yeah, there is a school that believes that deference at any point in the spectrum is both unconstitutional in spirit and letter of the law. But for other scholars, it really comes down to, as sort of Jace was alluding, really finding where the middle ground actually is. That really ends up for many scholars being the practical key in terms of sort of knowing what to sort of do from here.
Somebody wants to know, the readings for this course focused heavily on Chevron deference, but we know that there are other types. Can you say a little bit about these other types of deference, as well as what legal theorists think about them relative to Chevron? Are there some types of deference that are considered more acceptable than others?
Sure. There are two main kinds of deference outside of Chevron that most scholars talk about when we talk about deference. The first would be our deference, sometimes now called Kaiser deference, because there's been a more recent case speaking to the topic. And that kind of deference involves when an agency is seeking deference to an interpretation, its own interpretation of its own regulation. So if there's a regulatory interpretation at issue in a case, whenever our or Kaiser is involved, the agency is saying, yes, maybe the regulation is ambiguous, but the court should go with whatever the agency says it means. And the other kind of deference that commonly comes up is known as Skidmore deference, which is a less deferential standard than Chevron, and it focuses mainly on the ability of agencies to persuade judges that their interpretation of some kind of statutory ambiguity is better than the other parties. Kemp Barnett said that Skidmore is largely less controversial than Chevron, but he said Skidmore isn't really deference because it's talking about persuasion instead of forcing the court to yield to the agency's interpretation. He says courts are still in control at that point because there's nothing mandating that they make one decision or another. He said there's a debate over deference to agency fact-finding, and it would be hard to get rid of because we would need more judicial capacity to handle all the cases that would come out of whether agencies are measuring certain facts correctly. Because he says, as it stands, we don't have enough judges to process that kind of a caseload. For Adam White, he said that our or Kaiser deference raises special problems because agencies then are legislating, executing, and adjudicating their own policies. And so he thinks there might be a separation of powers issue whenever it comes to our and Kaiser deference. He also said that deference to the predictions that an agency makes is also questionable because agencies are predicting more and more things these days.
I just always like to point out that a lot of the ink gets spilled on Chevron and Howard and a few of these other sort of notable, or now Kaiser deference, notable deference doctrines. But most of this ink is consequently also spilled on doctrines that are national judicial doctrines, right? And that the states don't have to follow suit. Although some states have adopted things that look like national deference doctrines, some states haven't. Other states have outright prohibited deference altogether. Different countries have different judicial deference doctrines. So it's just worth noting that there's the world of deference is much more vast in scope and in practice than just the sort of the national deference doctrines that get most of the attention. Of course, in terms of like whether any are considered more acceptable and others, it's down to taste. It depends on your view of deference. But I think it was Jace that noted just a little earlier that deference, that Chevron, for instance, may be the most sort of household name brand of deference, has changed over the years and has narrowed in scope, I think, in ways that have probably over time made some people, if not warm to it, at least sort of less critical for those that are critical of the idea of deference in general.
And on that note, Chris, our deference has also limited and changed in scope over the years as well, especially in the 2019 case Kaiser v. Wilkie. And so Christopher Walker, in a law review article, he was arguing that our deference should actually resemble the less deferential standard of Skidmore deference, because our deference is similar to Chevron in that it's a rule-based doctrine. So it'll be interesting to see kind of how those doctrines continue to change and evolve.
The next question that we have for you is, someone would like to know, who do scholars think is more responsible for the current state of deference to agency interpretation, Congress or the courts?
Cynthia Farina argues that many people criticize Congress for giving up its policymaking powers to agencies, but she says that the courts and Congress both altered the original balance of power in the Constitution. Whereas Kent Barnett says the courts are more responsible, but Congress should be. He says most of our understanding of deference is based on developing case law, so that involves the courts more than Congress. But he did say that Dodd-Frank, the financial regulatory bill back under the Obama administration, was an example of Congress mentioning deference in a statute. So he thinks maybe they'll speak to deference more going forward, but that the court has generally been in the driver's seat.
It's an interesting binary, and I think slightly leaves out agencies themselves who play some role, or at least the executive branch, in choosing to implement rules that are ambiguous in the first place. That isn't necessarily something they may have to do, some might argue. And again, as I alluded earlier, some reform proposals argue that the executive should order agencies to stop implementing rules or promulgating rules in the face of ambiguities. Agencies play some role, I think, in this. I think it's the view of many that I think the responsibility is there's plenty to go all around, I think.
And the next question is, an audience member would like to know, what do you think about the argument that deference violates due process because it requires judges to exercise systematically biased judgment in favor of the government?
Farina kind of speaks to that question, and she argued in her article that Chevron certainly threatens to empower the executive branch in an unbalanced way because it leaves few effective checks on agencies' policy discretion. She wrote that even though agencies are theoretically more accountable to the American people than judges, it's still difficult to exercise political control over them. And so that's where you get into that bias in favor of the government angle. But I think she wrote this article before that became more of a mainstream critique of deference. Whereas Barnett responded directly, and he said he thought that argument was creative, but unconvincing to him. He said specifically because Chevron mostly applies to public rights that Congress has created, there have always been judicial deference in those cases. So Congress doesn't have to involve Article 3 courts at all whenever we're talking about public rights, at least in Barnett's opinion. And he said, in cases between two private parties, there's no chance for bias in favor of the government. Even if you're applying a government interpretation of a provision, you're still going to favor one of two private parties and not a government. And so he said proponents of the argument about due process and bias need a more nuanced approach if they want to prove that due process is implicated in the deference question. Adam White thinks that the due process critique is a strong argument. He said deference puts a thumb on the scale for the agencies involved in litigation. But he said at the same time, we have other examples of that kind of thumb on the scale in other areas of the law. For instance, criminal laws, when there's ambiguity, are construed in favor of defendants and not in favor of the prosecutor. And so due process is implicated for Adam White whenever people can't know what the law is until a court case occurs.
There's an interesting line of argumentation represented by, just for example, Daniel Ernst, a professor, wrote a book called Tocqueville's Nightmare about to what extent due process protections have actually over time been internalized in ways that you may not recognize, but are in fact there in their view in, say, regulatory and adjudication processes and in the actions of agencies. And so depending on your view of due process, if you are an adherent of that school of thought, then whether judgment is systematically in favor of the government because of these processes, according to this view, then judgment in favor of government is also judgment in favor of due process protection for citizens, right? So if you don't believe that, then you might maybe have sort of the opposite view that if due process has not, according to this view, been internalized in the processes, then you might have some sort of concern. So it's worth recognizing that there's a school of scholarship that believes that these processes have become internalized into the process, making this in some sense sort of like a moot sort of concern. But there are those who would worry that, of course, conversely, right, that if you're deferring to Article 2 doesn't necessarily have to have the same traditional due process protections that we expect from traditional Article 3 courts, right? But an interesting and growing body of literature here about the extent to which due process has been internalized over time in adjudication processes of administrative agencies.
Someone would like to know, can you say more about why some people think that the future is uncertain for judicial deference?
So the main thing is there are more challenges to deference precedents, and there is debate at the popular level about whether those precedents should remain, change, or be overturned. I mean, we're having this webinar instead of talking about some other administrative law concept. Just having these discussions and more challenges work their way through the court system provide more opportunities to change how deference works. Barnett argued that we will never be at an equilibrium because he thinks the deference debate is really about faith in administrative agencies. There will never be agreement on those issues because whoever's in charge of the agencies changes, and that'll generate different political coalitions to change how those agency actors behave. Speaking more specifically, Adam White said the future seems dim for Chevron, in particular to him. He said there are no proponents for the classic version of Chevron deference to agencies on the US Supreme Court, and there will probably be more restrictions on how Chevron works in the future.
Yeah, kind of building on that, I think just the inconsistent application of some of these deference doctrines over time kind of speaks to the uncertainty of their future. In that 2019 case I mentioned earlier, Kaiser v. Wilkie, Justice Gorsuch actually claimed in his concurrence that the inconsistent application of our deference in particular had created confusion for the lower courts. So I think it'll be interesting to see how that inconsistency continues to evolve over time and if it contributes to continued uncertainty.
Okay, wonderful. Thank you for your answers to those questions. I'm going to give it another few minutes in case anybody wants to ask a question. Okay, it looks like that was the last of our questions, in which case I think we're going to wrap up for the afternoon. Thank you again to everyone who joined us, and thank you again to Ballotpedia's administrative state team. Thank you very much for your answers to the questions today.
Thanks, Megan.
everyone.
Thanks, Megan. Thanks, everyone.
Thanks. Thanks, everybody.